Welcome. I'm Ada Kay, your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of java and let's dive in.
And we can do this cycle for another 2 minutes or take a break. Okay.
Hello, everybody. How are you all doing? I hope you're doing great. I am with my friend in the hospital, so we're going to be doing a remote live. Karen Reed is getting ready to start. We're just going to let it roll. I am here in the background. Thank you so much for joining. I'll see you in a minute. June, go ahead and roll it. Hey, June, can you just pull that forward, please, to playtime? There we go.
I'm doing good.
By the way, I did watch an interview with him. I'm going to do a show on that eventually, but it was quite interesting about what he had to say about this case and where they're going and what they're looking at and some of the things that are going to be happening and comparing the civil trial from the actual criminal trial. So this is going to be an interesting ride, and I'm looking forward to covering this. It'll be unique to be able to see the difference between how a criminal trial is run versus a civil trial. All right, if June, if you can skim forward to where the judge is talking, that'd be great. Thank you, beloved. And then I guess you'll have to control the volume on your side, June. We need you to turn the volume up.
I thought it was supposed to take short, small dresses.
Because I have no volume control.
So I was fighting.
Is your volume on, June?
Yeah, it's kind of just more like a regular breathing pattern. You want to focus, like I said, on the effort when you breathe out.
Angela, do we have volume?
Right, well, I'll see you when you get back. We'll do another treatment, but we'll do it a little bit longer, depending on how you do coming out of the anesthesia. May truncate it or not do it at all, depending upon how.
June, do we have volume? Can you give me in private chat?
California.
I have no volume.
Okay, come in, but you just can't leave. You know, now that I
June, I need you to unmute your volume on the live feed. We have no volume.
Anyway, well, you want me to just leave it where you do?
Okay, guys, sorry about that. We were having technical difficulties, but thank you, Angela. You were able to pop it in with volume. We are now going to go live with the Karen Reed civil case. I'll see you in a little bit.
Good afternoon, folks. Good afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please stand as well. Thanks.
Good afternoon. Good afternoon, Your Honor. Dan Buck on behalf of the plaintiff. Okay. Good afternoon.
With the defendant, Karen Reed.
Okay. Good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Mr. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Mr. Karen Reed.
Got it. Okay.
Your Honor, Christopher George on behalf of the defendant, Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
Okay. I'm sorry, did you say the waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Your Honor. Ken Kennedy also on behalf of Waterfall Bar and Grill.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon. Okay, that's all the counsel. Good afternoon, folks. Welcome everyone to the event for this afternoon. When I was assigned this case, Phil, in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial toward action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery and how that's all going. Counsel? People here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
I know the defendants with discovery. All of the defendants are currently, we have not received any as of yet, or it's from the DAs, so we are, is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was on. Documents, notices of depositions or no?
Only one deposition has been noticed and it's been tabled because we don't have any documents at this stage.
I see. Okay. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants, that's going in a different direction, but you're pursuing that sort of on your own?
Right, but we've also, I anticipate that the defendant matter to which we haven't ever received. So we have requested that both from the defendant and we've requested it from the DA's office.
Okay.
It is coming in. We should have it all within the next 21 days is my guess.
Okay. All right. Procedural issues from the defendants. We can start with you, Attorney Sigurdsson.
Thank you, Your Honor. As we're anticipating the status of this case, to inform the court that from Ms. Reed's perspective, those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights, negligent training, supervision, and retention of Massachusetts State Police troopers. We also claim Jennifer McCabe and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, what we'd like to ask the court's indulgence for is we have a luminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the house diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted house were either police or police adjacent who were socially and personally to ensure that what happened in the house was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face facing allegations of wrongful death. These claims and parties in. What we're asking the court to the complaint. We've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties more 20 days to respond so that the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it.
At a minimum, you're going to rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be in a very unwieldy, this accounts for trying to conserve judge at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and this which Your Honor has broad discretion to allow. The point being, the claim should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond.
All right, let's hear it then from the Waterfall.
Yes, Your Honor. We are in progress until next month. We anticipate that will be completed. Then we as well.
When you say an extension, this is an agreed to extension?
Agreed.
Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then consider closing depositions yet until a lot of the document requests have been answered. And the subpoenas for keeper of records, we haven't seen any of the records. We're aware of them certainly from the criminal that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all.
All right. Let's hear from C.F. McCarthy, then.
Your Honor, with a similar vote as is the last leg of it is just direct communications. From a copy, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then, in terms of the response to the procedural issue that was raised, in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your Honor.
It's the first notice you've gotten?
Of course, I would
Not how
expect.
the court system likes this stuff to work, folks.
Right, I would expect the courtesy of the meet and confer, or at least let me, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe Your Honor would have to go up through a state court, Plymouth jury decide this case. So who are involved. Sorry.
All right. Any response, counsel?
Asking for permission to serve a motion to proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. Brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Narrative of what took
But it
place.
is though, it's the plaintiff's, well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have, at its essence, is a wrongful death action. Be allowed to amend these for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as
depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling, like to at least have the opportunity to make argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right, so I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct? And Ms. Reed. So that's the way the case is now. The tracking order, I think, basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend it, depending on what the homicide case earlier. I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get to a trial date as soon as practically this spring. On this case, but to join 10 new defendants under wholly separate theories for people that haven't even been joined yet, it puts that on its head. There's no way we could, you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to tension, because there is going to be an affirmative.
Well, you're saying affirmative. You said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing them at the same time. That's what we're trying to suggest maybe a more streamlined approach. And it doesn't economy without prejudicing the plaintiff. Discovery is already ongoing, but you have two depositions, for example, of parties in two separate cases. We're raising it. We'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I certainly am not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, that the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence/reckless/intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out, the temporal, spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother. Again, they were not witnesses to the event. They came upon many hours later. That is cited in our brief. Speaks to the time that a family member or a bystander witnesses the court said that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here and the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singular.
To the other defendants, if they want to be heard, you've filed separate motions essentially arguing the same relief, but if you have anything you want to add, you certainly can. The waterfall?
Yes, Your Waterfall, just very briefly. I think the distinction here the council's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're precipitating witness. And in this instance, it's seeing the decedent in the hospital. I think it's after 7. In terms of the principle that the courts have applied here, it just isn't from to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages are in fact addressed in that statute to the plaintiff.
Semino versus Milford Keg Incorporated. I have 1980 in a distress.
Okay, guy, my friend just is going, we're taking her off to
Jury's
surgery.
323.
Thank you guys so much
1982
for
case.
watching. I'm still here.
It would seem to be for that statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the accident, since it wasn't witnessed, just immediately thereafter that they came upon the scene in a roadway, in a drive. Your Honor, that's a problem for the plaintiff moving forward. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell's sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss? No. All right, great. I'll take that issue, reread a little more closely. Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both corporate defendants and Ms. Reed.
Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor. Does the plaintiff's complaint plausibly suggest that plaintiffs are? Answer is yes. To dismiss the lowest standard, the Brum case, plaintiff's obstacle is a minimal, relatively light burden, so long as the court looks at the allegation holistically. If relief to the plaintiff is possible, by the cumulative effect of all the factual allegations pled. We survived the motion to dismiss. By creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendant's own vulnerabilities of the plaintiffs when evaluating violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, is important and significant that I at least highlight the ones throughout. We intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. '22, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she's the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that he is a vulnerable child, two parents tragically, and 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee. He's been hit by a plow. Did I hit him? All to a 4-year-old woken up from sleep who's lost two parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness. At around 6 a.m., they rush to the hospital. It's 7:50 a.m. Within minutes of being pronounced dead, that's when the injured state that he was in as a result of the ride. Forward, Your Honor. Karen Reed plots, she fabricates a conspiracy. She launches a public campaign of disinformation, and she involves information through him. She pits her followers against the O'Keefe family. Is tragedy. The O'Keefes and Kaylee suffer stress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. That's their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, misstates Massachusetts law. You have pointed out the Cimino case, where, let me just statute, it has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, you're against the drunk and the bar for overserving him. The father brings two separate causes of action. One for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the submit to point that out. It directly contradicts everything that my brothers just argued here in this court, and I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. But the law does not endorse such a narrow, arbitrary interpretation of the law. On the time, because let's look at the law itself. The liability for NIED depends on number of factors. Where went to the consciousness of the plaintiffs? And it also requires, but I repeat, where was it is misplaced for the matters that plaintiffs were not out. The Farrader stands in the exact opposite. Richard has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital. so long as the shock follows. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness. Persuasive authority from the Zachary case that shows that IED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness. 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She hides the injuries from anyone, that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone, does not experience the injury, and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim. To suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night. And is now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own two eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions to suggest that you can't use and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all. I'm learning that your close family buddy, but to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why second, we also suggest that you should deny it because they experience the injuries. Closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defense argue that the intentional / reckless infliction of emotional distress claim should fail because extreme or outrageous conduct directed towards the plex. Demonstrate that Ms. Reed should have known her extreme and outrageous conduct plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be resist infliction stress standard. So how do we evaluate what is extreme and outrageous? It's that susceptibility between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous. Defendant's conduct was extreme and outrageous. The courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly 8 years. The defendant, Ms. Reed, knows that she knocked JJ down. to the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his. She actively talking. Then, after creating this chaotic upset, she leaves her. She leaves her home alone, shocked and frightened by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that the discovery will reveal evidence. And John have now buried 2 children. Paul always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case is nicely within and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polite case where we talked about false police reports and harassment were not considered towards emotional distress, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at. What is doing is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in a complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see his son. It's contemporaneous. It's at the time of the event. And the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint, and again, for the record, so that people understand this is a pre-discovery counsel complaint, and the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that it might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envisioned for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by from a more pragmatic point of view, and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit. 10 additional parties. Being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inability to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is get when you go through the litigation process. You go through when you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here, clients can ask a verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. The clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. Process, we'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out. We can restore, we say this when people lose loved ones, or that they have some, we can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. That there's a huge opportunity to do like this. And I've heard parties have very frank discussions with the lawyers about that. And I'm not going to explore with your clients the time to get to litigation, what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have two ongoing, as far as I understand, the two businesses in Canton are ongoing, and they have their business decisions they have to make. Ultimately, they're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment.
Guys, I am in the waiting area. Hey guys, thank you for pausing. Hey guys, be in prayer. My friend is in surgery right now. They are doing a biopsy on her lung, and it's pretty scary right now for her. So keep her in prayer. But I just wanted to let you know I'm still here. I am listening. Thank you guys. Thank you, my mods. Y'all are so amazing. Thank you so much for figuring all this stuff out. All right, back to court.
And behind and going forward, it's going to be very complex. So you can resolve that by looking at putting some effort into this. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay. Great. But here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right? When do you want it just as easy? My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, you tell me, plaintiff?
We're agnostic, Your Honor. I'll do whatever.
We're agnostic? Is that what you said?
Your Honor, we prefer to be in person.
All right, we'll do it in person. All right, we'll do it down here in Plymouth next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, executed this.
November 21st, Friday in the end of November.
Yeah, that November 21st. Okay, I'll have a decision out before then, certainly, as quickly as I can. 11/20 recovery, and any motions, Rule 15 motions to amend or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor.
All right.
Nothing with the jury?
I don't think so.
So I think we have it. I will go back and look at this a little closer and do a deeper dive myself. And then maybe in a day or so, we'll come back and dissect everything. I'm sorry, my attention could not be fully on you. I just wanted to have it available for y'all and y'all to be able to watch it. Mods, June and Angela, thank you so very much. Angela, give me a thumbs up if you're doing okay. Are you doing okay, Angela? Okay. I love you guys so much. We will definitely be back on. I will have a better idea tonight as to what the plan is going to be, what's happening, where we're going, and when my next live will be. So y'all keep an eye out, click the bell, make sure you have the bell clicked and you're subscribed so you know when we're going to go live again. I will have a chat with my mods tonight and we'll have a plan formed for the rest of this week and let you know what it is. But thank you once again for joining and as always, loving on me and being there and supporting me and my family and friends. In the meantime, y'all have a fabulous and blessed day and we will see you soon. Thanks so much. Bye.
Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.